Good morning, everyone, and thank you very much for joining us for today's webinar, Understanding the OAA Complaints Process and Professional Misconduct. My name is Shalika Sivathasan, and I am the Administrative Assistant in the Continuing Education Department at the OAA. We will begin today's webinar by acknowledging the land on which we are meeting and calling in from today. For millennia, the place we call Ontario has been inhabited by Indigenous peoples and nations who have been stewards of the land and who are deeply connected to its rich cultural and natural landscape. We would like to invite you in a moment of reflection to acknowledge our shared responsibility to address past and present injustices and provide space for Indigenous knowledge and worldviews to shape the architectural landscape of Turtle Island. Before we begin, I would like to share some important information to ensure an effective and professional webinar experience. Please be informed that this session is being recorded for quality and educational purposes. For accessibility, we provide automated closed captioning service available in multiple languages to accommodate the needs of our diverse audience. In order to maintain a stable internet connection, we have muted all participant microphones and disabled video feeds. Kindly note the chat function has also been deactivated. However, we do highly encourage engagement through our Q&A window, which you will find at the bottom of your screen. Feel free to submit any questions you may have for our speakers there. These will be addressed in the designated question and answer period at the end of the presentation. For those seeking continuing education learning hours, please note that attendance is crucial. A minimum of 80% attendance is required for these hours to be accredited to your OAA transcript. Please allow a few weeks for the processing and reporting of these hours. And lastly, please note that the presenter does not provide insurance, legal, or practice advice, and that the OAA does not bear responsibility for errors or omissions in discussions during the webinar. Now, many of you will be familiar with our speakers for today. Claire Hepburn is a lawyer working in the area of professional regulation, and of course, she currently serves as a Deputy Registrar of the Ontario Association of Architects. And Toon Dreessen served as President of the OAA from 2015 to 2016, and is a member of the RAIC College of Fellows and the Order of Da Vinci. He leads Architects DCA and is responsible for award-winning and high-profile projects. And with that, please welcome Claire Hepburn and Toon Dreessen.
Thank you so much, Shalika, for that warm welcome. And it's nice to be sitting on this other side of the webinar land and getting to give you some more information about the OAA complaints process. As Shalika mentioned, I'm not an architect, I'm a lawyer. Before working for the OAA, I worked for the Law Society with lawyers, so professional regulation is very close and near and dear to my heart, as is working in the public interest. And Toon, if you want to say a few words about your role, and then we can begin the presentation.
Sure. So being a practicing architect and also being involved in the OAA is a really great opportunity. It really helps helps you improve your practice and improve your understanding of not only architecture, but how architecture is administered and how it is protected. So as a small plug to suggest people volunteer if you're interested in committees and council and so on. It's a really great opportunity to become engaged and makes you a better practitioner, and I think makes you a better architect. Certainly being engaged with the complaints committee is a really good opportunity to see and experience what the complaints process is like and understand the core functions of the OAA as a regulator, which is, I think, critical and crucial and not as well understood by both our profession and the public as I think it should be.
Yeah, well said. I'm just gonna take a brief moment to go over what we're gonna learn today, and we're gonna get into some really interesting poll questions. So make sure you're near to your camera and can answer these questions so that we can get a sense. We're not keeping score, so please answer as honestly as possible, and yeah, please do engage. So first of all, obviously as Toon said, we want you to understand not just about the process, but why it exists and the whole function as it relates to this regulatory framework of the OAA. We hope that by the end of this, you'll be able to more clearly and confidently identify what is misconduct and where to find it in the regulations. And then we hope to leave you with some really good best practices to avoid complaints, because I don't think anybody wants to, or at least mitigate the risk. You know, we can't predict what people are going to do, but there's certainly ways to set ourselves up for success as professionals. So I'll ask Shalika to launch the first poll question, and maybe you can read it out, Tone, for everybody.
Sure.
If you see it on the
So
screen.
poll number one, what is the primary purpose of a regulatory complaints process? To promote public awareness of the profession, to promote professionals, to support professionals in their career development, to manage internal administrative procedures, or to ensure professional accountability and protect the public. So please select one.
Just one answer. And
now we make Jeopardy noises.
I know, and I can't see, I don't know if Shalika, you can see when, normally when I'm on the other side, I think now as a panelist, I'm not able to see how many people. So when you see a good number of people who've answered, you can close the poll. I'll leave it in your discretion to post the results when they're available. Oh, okay. Wow. We've got a very well-informed audience today. Only 4% got the answer wrong. And it's not even technically wrong. It's just not the primary purpose. The whole primary function, and I'm going to talk about this more, is to protect the public interest. So, well, I'm very impressed to see that everyone's clear on that. So now I'm gonna be talking for a little bit about some of the more let's just say legalistic, heavy kind of topics, and then we're going to move into some more interesting hypotheticals. So do bear with me. I don't want to lose your attention, but I think it's really important to understand the whole notion. And obviously everybody on the call today understands that protection of the public is the core function. The reason for that is that the whole ecosystem of self-regulation is there so that the government contracts with professions in order to delegate the responsibility of setting the standards of competency and safety to the profession, because it makes sense. It takes a lot of skill, time, energy, experience to develop those skills, to become a professional, and specifically become an architect. And that ability and innate knowledge of the profession allows the profession to really govern itself best. At least that's the idea. And so that's why we really see self-regulation in professions where those services come with an inherent level of risk to the public and the public welfare. If you think about doctors or lawyers and architects, obviously, you don't want to see an untrained or unskilled practitioner, because there could be, serious risk. Just to also give you a little bit of context, architecture exists amongst 13 other non-health professions that are regulated in Ontario. There are also 23 compulsory trades and 26 health professions that are all regulated under a separate umbrella. And just to kind of contextualize where architecture fits, or specifically the OAA, we're one of the older professions in Ontario, established in 1889. And currently, that I checked last night, we have 5,250 licensed members, 1,993 practices, and 2,033 interns. And it's actually quite a small profession when we compare it to teachers that have well over 100,000, nurses as well. And I just checked with the Law Society, it's now up to about 70,000 members. So in the grand scheme of things, a very important profession, obviously, but still quite small.
If I could just add briefly to that, this is why volunteering and being engaged is really helpful. The engineers, often we all work with engineers, and back in the day, we sort of said that there were about 5,000 architects and about 100,000 engineers. Now 100,000 engineers includes a large number of engineers who are not at all related to buildings. So they're, chemical engineers and all kinds of other, rocket science and whatever. But there's still about 25,000 engineers in fields that are related to buildings or have associations with buildings. So structural, mechanical, electrical, civil, communications engineers and so on. So we are quite a small profession, and the OAA at about, what did you say, about 5,200 members, is about a third of all of the architects in Canada. So we are a very small profession, and it's really important that we work together. And that's part of that piece of that social contract, is that we work together to promote and support the idea of architecture and its importance and its relevance politically to society, because what we do affects, climate change, affects, social well-being, budgets, health and well-being. There's so many factors that we touch on that it is a crucial industry that is not as well understood by both the public and politicians, who really don't necessarily realize the impact. They just sort of think we sit in a corner and do blueprints while wearing a cape and black glasses.
Yeah, I like to think of the OAA as small but mighty. We do a lot, and we're going to show a bit of a slide to show what we do. But the next slide, again, I wanted to just illustrate an idea of how we come to specifically the complaints process. And this illustration here, or infographic, is kind of like a nice visual to try to distill a lot of complex ideas. The first step along the roadmap, and we're going to get a lot more into specifically the regulations today, and the Architects Act that does set out the Complaints Committee and its role and responsibilities, but it's really in the regulations where we learn more about misconduct. But that actually sets the whole framework for what gets regulated, how it gets regulated, how it unfolds. As I noted, and everybody on the call knows, the purpose of the role of the OAA is to protect the public interest, and that's enshrined in the Architects Act, in the primary object of the Act. So everything that flows, all of the rules, all of the systems, including the Complaints Committee, the Discipline Committee, all flows from a requirement that the work be done in the public interest. The Architects Act then delegates that authority to a professional body, which is the OAA, and that body will establish the responsibilities. So in addition to complaints, we have to enforce standards, oversee the licensing process for new members of the profession. We have to establish the academic requirements for entry into the profession, and then, of course, manage ongoing competence. Then, in addition, and we're going to get into the more nitty-gritty, those responsibilities of the members are set up. So you have those duties to pay your dues every year, to make sure that you're filing the appropriate, if you have a practice, to file the insurance, to maintain your continuing education hours that you're all doing today, for example. So all of those responsibilities, and of course, to maintain that level of ongoing competence and professional conduct, that we will be getting into more. And then finally, there's government oversight. So I think maybe a lot of people don't think about it or assume that this self-regulatory framework is an unquestioning and unwavering privilege that would never change. However, as we've seen kind of in the west of Canada, there have been challenges to regulatory bodies, and there have been specific instances of regulators who've either lost their right to self-regulation or it's been significantly diminished. So it is something that we are ever vigilant about, and we have to be responsive and maintain a really close eye on those trends and the responsibilities to manage the profession in a way that ultimately protects the public interest.
If I could add, some of the people some of you may have seen in the news, that the real estate regulatory body has been questioned because of, inconsistencies in how I think it was some trust funds were being managed or how certain accounts were being done. And these are transgressions of the public interest. And if architects were suddenly, suddenly being questioned as to our integrity and our ability to serve our primary object, that would be questions that we would have to answer to the Ministry of the Attorney General, who we report to. And it's kind of funny that, having been president, having met with the Attorney General, and then you meet and they it's not that they question like, why are you meeting with me? But they don't really have that kind of they're not responsible for building codes or, climate change or any of the other things that we think of as part of our day-to-day practice. But it's because it's that sort of legal importance that we also, we report to the Ministry of the Attorney General. I think the engineers do as well. And it's because we have that sort of legal structure that we have to be responsible to a minister. And then as Claire mentioned, we talk to and interact with other ministries like building codes and services and housing and other ministries that have that impact. And research we did nationally showed that at the time there were 35 federal ministries, and architecture interacted with 30 of them. So there are a lot of places that you as an architect touch, but you report to the Ministry of the Attorney General.
Wow. I was not aware of that stat of 30 ministries that architecture touches. That's very interesting. Okay, so, and again, this is going back to what the OAA does. I'm just showing this slide to show where complaints and discipline fits amongst many different, as I said, small but mighty, many different functions that the OAA undertakes in order to fulfill its duties under the Architects Act. And at this point, there's another slide that I wanted, maybe Tone, you could read out the slide as it comes up on the screen. And Shalika, if you could launch that now.
Yep. So how familiar are you with the Architects Act and Regulations 27 and/or the OAA bylaws? So please make one choice. I am not familiar. I rarely refer to them. I consult them occasionally, or I'm very familiar with their structure and content. So please select one.
Please be honest here. Like I said, this is anonymous. We will not see your name. We'll just see the numbers and the percentage.
No complaint will be filed.
No complaint will be filed. So we just want your honest answer, just to get a real sense of where we're at on this call. And I do have a sense that the people who do sign up for this webinar are probably going to be more diligent than the profession, but it's okay. I mean, I'd love it if the people who are really wanting to learn about these rules also signed up. So please be honest. That's my pitch for honesty. Okay, let's see the results. Okay, I like this. There's a really honest answer, and there's only 18% on the call that said they're very familiar, which is great, meaning most people on this call are hearing and hopefully learn something today. And I'm curious too, of those 18% who really are very familiar, if they're going to come away with something today too. And then again,
they're all members of the complaints committee.
Yeah, exactly. Or their staff, because we do have some staff on the call today who administer the complaints process. So I know what their answer is going to be. Now we have another poll question, and we're going to go right into this next poll question, which is a little more of a skill testing question. And Tone, if you don't mind reading this for us.
Sure thing. So under Regulation 27 of the Architects Act, what are an OAA member's responsibilities regarding professional misconduct and complaint? So please choose one. Members should only respond to complaints if they are directly involved and are not required to report others' misconduct. Members must promptly report any suspected professional misconduct by others to the registrar and reply promptly to any correspondence from the registrar regarding professional conduct. Or members are required to report misconduct only if it affects public safety, but can delay responses to registrar communications until after legal advice. Or lastly, members are not obligated to respond to complaints or report misconduct unless formally asked by the complaints committee.
Thanks. Yeah, this one's a little more heavy reading, but just go with your best instinct. And we'll take a couple of beats for people to digest those. It's a bit of a longer poll question, but it's a really important thing to know. Just give it a couple more seconds here, and then maybe get ready to close it off. I don't know how we're doing with the percentage wise, but I'm very curious about this one. Okay, good. It looks like most people got this one right. Members must promptly report any suspected professional misconduct by others to the registrar and reply promptly to correspondence from the registrar. So there's two, this is again a pretty specific section of the regulations. And so where this is coming from is section 49 amongst the standards of practice that says every member must promptly bring to the attention of the registrar any act or omission by another member that may constitute misconduct or incompetence. One thing I will say about this, and we're going to get into like the mechanics of filing a complaint, this doesn't require you to file a formal complaint and be a complainant. What I would suggest anybody who thinks that they're in this position and they witness misconduct is to give us a phone call or an email. And if it's something that we can help with and in our jurisdiction, often what I'll do is I'll have phone calls with potential complainants, and then we can assess whether it's something that you would need to file, and if you would want to, and all of the details there. So don't go out and file a complaint if you see any little suspicion. It's best for you to call the OAA first and have a quick conversation.
And I guess I'd add to that, there are times when there is something that may need to be investigated, may need more information, may need more, more research to do. And that's not the job of you. It's not the job of the member. That maybe it's the job of the OAA or the registrar to do that work. And if you do it and investigate a bunch of evidence and send Claire an email of like, here's all this stuff I found, and here's this, and here, you may actually compromise the ability of the OAA to do anything about it. So it's better to reach out to the registrar's office and flag the issue and see if there's something that is more specific that needs to be done, or give them the heads up so that they can undertake that work.
Yeah, no, that's a really good point. And there is something I didn't go into too much detail in the speaking notes, but we'll talk more about the specifics of you filing a complaint or an individual filing a complaint with the OAA. If that process is undertaken, the complainant isn't allowed to be anonymous, and in turn will get a result of they'll get the decision and reasons, or they'll know what the outcome of that complaint was. If you're providing information and then the OAA is doing the investigation, just the way that the act has been drafted, the OAA is required to maintain confidentiality of that investigation. So you would give the information to the OAA, and then you would entrust that information to the OAA to conduct their investigation, and you wouldn't be able to get updates about it. So just be mindful of that fact. And that's the same as well for act enforcement matters about illegal practice, very similar. The other point I just wanted to make out was that failing to reply promptly to any letter received from the registrar about professional misconduct or competence could be also considered misconduct in and of itself. And this, when I was specifically more of the Law Society, because lawyers tended to be, well, there's more of them and seem to get into a lot more trouble. There's a lot of volume. The one area where you see lawyers getting into the most trouble, and I've seen this with architects as well, is when you don't respond, when you avoid dealing with the issue. So if you do get a letter, and regardless if it's misconduct or another regulatory matter, it's very important to be responsive to the OAA. Nobody really wants to get that letter, of course, but I think it's probably safe to say a really good best practice for anything in life to just deal with something you don't want to deal with right away.
And I think it's also from the perspective of being on the complaints committee that, when there is a complaint, if the member has, was given a letter and said, hey, you need to address this, and then they don't, and then there's a follow-up letter and there's no response, and then a follow-up letter or there's a follow-up call, and that process eventually results in a response, it doesn't look good. It's like trying to avoid, your court date. It doesn't look good. It doesn't work well if it feels like you're being non-responsive. And if there's a reason you can't respond, if that you get a letter or a notice from the registrar and you can't respond because you're ill, or you've got a family health emergency, or there's a legitimate reason, then and you can't respond in the time frame that's been asked for, then you can respond and say, I got your letter, but I need more time because of A, B, and C. And that the registrar is not unsympathetic. They will acknowledge that, and they will ask for a reasonable time frame and then hold you to it. So take the time it needs to go through the requirements and respond in a timely way.
Yeah. Yeah, and as I discussed this, it's important to note you could be the complainant, so the person who's filing the complaint, and then of course you could also be the person who's receiving the complaint. So when I'm giving this information, I'm kind of thinking of it through both of those lenses, and giving you information so that you have a better sense of what the process looks like, so that it's maybe not as overwhelming if you're confronted with the situation on either end of the fence. So I'm looking at the time. I'm going to go through there's 10 steps that I've outlined, and all of this information again is available on our website. At the end of the presentation, I've provided a link, so you don't have to memorize this or absorb it all right now, certainly, and some of it might be less pertinent to what you need to know today, but I did want to just give you that overview so that you get a sense of what the OAA specific complaints looks like. So the first step I would say is just deciding whether to file a complaint. And that's when, again, I'll make that pitch for phoning the OAA. Once you filed a formal complaint, that that triggers a bunch of steps under the Architects Act that have to be undertaken. It will have to, in almost every instance, go to a complaints committee. And I'm going to talk about those other steps. So if in almost every instance, I can't really think of any instance where you wouldn't want to have that initial phone call. Please do set that up, and then we can go through the facts. You can't, when you have a conversation, you'll never be given advice about what to do, but you'll at least have information, and that will make your decision easier. So once you've had that phone call, or once a complainant, again, has that phone call with us, or sometimes not, we often will get complaints where we haven't heard from the person before. They'll prepare the form. There's a specific form that you'll need to submit, and that's a requirement. If it's just an email complaining, that doesn't trigger the requirement. It has to be submitted through the OAA's form. There are a number of acknowledgements that you'll have to sign. Again, you'll have to agree that this information will be shared, specifically your contact information and all the details in your complaint, with the respondent to the complaint. So the person you're complaining about is called the respondent. And then the complaint will, sorry, I think I'm skipping and confounding a few, so my apologies. This is more of like a 6-step thing now. And then once we've received that copy of the complaint, the coordinator, who is actually on the call today, she will acknowledge receipt of that complaint, and they'll see if there are any jurisdictional issues. Sometimes it'll just be like the person they're complaining about isn't a member of the OAA, and then we wouldn't be able to investigate any further. Once there's been a determination of the fact that we do have jurisdiction, and I will say in most instances when the person's a member and an active member of the OAA, that would be sufficient. then the document exchange process begins. And that document exchange process is set out in the Architects Act. And so the complaint will be forwarded to the respondent, the person who's being complained about, and the respondent will have 14 days to provide a written response to the OAA. That written response will go back to the complainant, and the complainant will have another 7 days to respond. There is, and I think, Tone, you mentioned this, if you need more time, if any party really brings forward an issue where there's an illness or there are other life circumstances that would warrant an extension of time, that can be granted by the OAA. It can't be granted indefinitely because there are concerns around procedural fairness and delay in preserving evidence. However, it's often the first request will be granted without further question. So it's really important if you do need that extra time and there's a valid reason connected, not just simply like, I don't want to do this, but there's a valid reason, that those deadlines can and are extended. Once the documents exchange process has been completed, that's when it goes over to Tone and his committee, and it will be assigned to a panel to review all of that information. In order to have quorum, and this again is set out in the Architects Act, there needs to be 3 members of the committee and at least one in that 3-person panel. There has to be one member who's sitting on council, who's an elected member of council on that panel. And the committee also has an LGIC, or Lieutenant Governor in Council, who is a member of the public who is appointed. And again, that's a really important process, to have members of the public who are involved in the governance and statutory committees of the OAA. They're the voice essentially of the public that really connects back to the public interest. But generally speaking, the majority of the committee is going to be made up of peers, of members of the profession who understand and can interpret the facts of the complaint in accordance with the best practices and the standards of the profession.
And I could just also add, another thing that also comes up is that before the details of a file are shared, sort of a summary is shared with the panel, so that if somebody has a conflict of interest, you know, then if the complainant or the complainant or the complainer is, you know, your neighbor, a friend, somebody you went to school with, a coworker, or something like that, the panel members have an opportunity to say, no, I have a conflict of interest, and you don't disclose necessarily what that is, but you have the ability to step out of the panel, because the panel has to be neutral. And that's an important part of the LGIC role, is that this is not a complaints process in which we kind of like panel gets together and says, oh, good old Joe, and we'll forgive him this time. It has to be transparent, and it has to be accountable. You know, it can't be something, it can never be ever perceived as something where we protect our own, where our role is to protect the public interest. And so the opportunity to disclose that you have a conflict of interest, and to ensure that the public interest is protected, with including a member of the member from the LGIC representing the public, so we ensure that the public is protected in the entire process. Sorry.
Yeah, that's a really, really good, important point. And there are a lot of mechanisms that support that. But yes, that initial, even before we get to the consideration of the complaint, is one of those core requirements to ensure procedural fairness throughout the whole process. So once the document exchange process is complete, the committee will also decide if there's additional investigation that's required. And that's one of their duties, is to make sure, again, balancing that with the appropriate level of risk. Sometimes, or oftentimes, there's no additional investigation because it's already, all of the information has been sufficiently provided to make a clear determination about the evidence. But oftentimes there'll be a further investigation, which could look just like a few more questions, or it could go to the level of requiring an outside investigator to conduct an additional, more thorough investigation. at which point the committee would then review their external investigators' report, make determinations. Again, the process that's why it's hard to predict how long the complaints process can last. And I'm sure people have that question. It could go anywhere from a few months by the time the document exchange process is done. And if there's all that information, you could have a decision in maybe 3 months. Or it could take as long as a year if the investigation or there needs to be sourced externally, or if there needed to be additional time given to any of the parties for other reasons. So it's really hard to predict, but once the investigation has been completed, then the committee will actually render a decision. And going back to the Architects Act, that is where you will find the specific requirements and parameters for the committee to make its decision. And there are really only 3 outcomes that can happen at the complaints level. The first is that the complaint is dismissed. The second, that is referred to the discipline committee. The second is referred, and the third is that the committee takes such further and other action as it considers appropriate, which again is a fairly broadly and vaguely worded section. But what that often will look like is there's a remedial step that the committee might say, okay, there's evidence of misconduct here, but the matter isn't serious enough to warrant the full force of the discipline committee. So it could be a caution, it could be additional education or coaching, or taking certain courses, that kind of remedial action. And I will say, if the matter is dismissed or not referred, so that includes the remedial steps, there will be a decision and reasons provided to both the complainant and to the respondent. That decision is not part of the public record. The Architects Act, unlike other regulators, it is not disclosed, is not published anywhere. The only decisions that are published are the decisions of the discipline committee. So again, that's an important thing to know about the current state of the OAA's complaints process. If it does get referred to the discipline committee, then that outcome does get published. And so that, in a nutshell, is the complaints process. I think we are now moving on to some more polls, and maybe if I could ask Tone again to read poll number 4.
So, poll 4, which of the following would constitute professional misconduct for OAA members? Charging a client a higher fee than originally quoted due to unexpected site conditions after notifying the client. Declining to provide a client with copies of design drawings until outstanding invoices are paid. Knowingly making a false statement in an application for a certificate of practice. Delegating administrative tasks such as scheduling to unlicensed support staff. These are good questions.
Yeah, they're dense. So you need to kind of sift through a lot to assess. And after we get to this, I'm gonna give you a bit more school time in terms of where to find all these sections and make sure that you know, like, I think what I really ideally want is for everybody today coming away from this webinar knowing where to find the information. That I think everyone's instincts after a certain point know when there's something awry and where to go to get that specific wording, because a lot of things can seem like not good, but there are specific definitions of what is and isn't misconduct. So maybe if we can see the results and if people have answered. Wow, I am impressed. It's 96% of you know that that's misconduct. Or maybe I'm not making these questions hard enough. But I actually thought they were pretty hard, so this is great. Yeah, so specifically 4215 is the section that says knowingly or signing or issuing a false or misleading certificate or report is under the definition of misconduct at 4215. And so to answer this question, what constitutes professional misconduct, there are actually two branches that have to be considered. There's the definition of incompetence, which is listed in the Architects Act at section 34 sub 3, which states that the discipline committee may find a member of the association or a holder of a certificate of practice to be incompetent is if it is of the opinion that the member or holder has displayed a lack of knowledge, skills, or judgment, or disregard the welfare of the public or holder, of the public, the member or holder. And this is where I need my glasses to read this, and serves to the extent that demonstrates that the member or holder is unfit to carry out the member or holder's responsibility under the Act, or the member or holder is suffering from a physical or mental condition or disorder of a nature and extent making it desirable in the interests of the public or the member or holder that the member or holder no longer be permitted to engage in the practice of architecture, or that the member or holder's practice of architecture be restricted. So there's kind of two components to it, as you can see there. Again, those are very broadly worded. What do they mean? Subjective sections of the Act. Then we get into section 42 of the regulations. I've provided again a link for those at the end of the presentation. There are 54 subparagraphs. I will not read out all 54. Suffice it to say, they can all be found there. And then, not behind, but following section 42, section 43 of the regulations deals with specifics around conflicts of interest, and there are somewhat densely worded provisions around what constitutes a conflict of interest, how you can opt out of conflicts of interest, and what are the kinds of conflicts that you can't avoid that will always be conflicts. So again, very important to read those sections. Section 47 deals with standards of practice for certificates of practice. 49 deals more generally standards of practice. And then section 50 will deal with performance standards with respect to general review. So that gives you the framework of where to go to find out if what you're doing could be construed as professional misconduct. So I think now we've got some moving on to some hypothetical scenarios, and I'll pass it back to Toon to read out this specific scenario.
So Jamie is a licensed architect in Ontario who takes on a small commercial renovation project for a repeat client. The client insists on an expedited process to obtain a building permit and tells Jamie, just do what you need to get through this. We'll worry about the rest later. So to help move things forward, Jamie signs the commitment to provide general review, knowing that his firm doesn't have the time to perform the review during construction due to other commitments. Jamie has also not negotiated or billed the client for the general review service and knows that they won't be compensated for it. The client submits the signed commitment to the municipality, which issues the building permit based on the assumption that the general review will be conducted as required under the building code. Jamie never follows up once construction begins. So which of the following actions by Jamie would most clearly constitute professional misconduct under the regulations? A, agreeing to take on the project without formalizing a written contract or scope of services. B, not receiving payment for general review services due to the client's budget constraints. Or C, signing a commitment to provide general review, knowing they could not fulfill the obligation. Or D, proceeding with permit drawings, even though some final design decisions were still pending.
Thanks, that was a long one to read. So
That's a long one to read.
there's a lot of facts in this, but yeah. I don't know if this is reminding you of your days of writing the admission exam, but it's kind of reminding me of the bar exam, all these if this, then this questions. So hopefully we're not stressing out our callers too much. But again, there's no report card, there's no pass fail for today. And maybe we'll, since we've had a long time to look at this one, as it's been read out, we'll see if there's,
And survey says,
survey says, surveys.
excellent. Look at that.
Wow.
Look at that.
Look at this, 100%. Okay, people are just getting smarter and smarter. I'm feeling very proud.
If I can add, an example of here, something that does come up sometimes at complaints and otherwise, is that, you can agree to have a contract without a formal written contract. Like, that's okay. It's not good. It's not a good business. It's not good to have a defined scope of services. It may be something that if things go pear-shaped and there's a complaint filed and you have no evidence that you have a contract or a scope or services, that's something that could result in a caution and recommendations that you take, remedial coursework and stuff to better understand that. But it's not against the act. The piece that's against the act is, item 3, which is signing a commitment and knowing you can't do it. So,
Yeah.
it's important to understand that.
Yeah, and I've got like the reason we included this scenario, there were a lot of things thrown out. There are a lot of sections that, again, we don't know enough about the situation on the reading of any hypothetical to know whether there would be a finding. And ultimately, I will say it's not the role of the complaints committee to make findings of fact, whether someone is or is not guilty of professional misconduct. Only a discipline committee can make that decision. However, what they're looking at is there evidence of that? Is there evidence of maybe someone's not following the building code? I don't know. There could be an explanation as to why something happened or information that's missing, but is there some kind of evidence? Section 4213, again, comes up a lot, because when you look at the wording, undertaking to provide architectural services at a fee that's not fully disclosed, fair or reasonable. Fair or reasonable, again, these are subjective terms. What's fair and reasonable? It could also be that you're not charging enough, right? Like that's come up. And in fact, probably even more common. More often, right? Where an architect is like, oh, I'm doing somebody a favor and I'm just charging him very, very little. That's actually where people can get into trouble because there's certain assumptions that are made. You don't have time or the resources to do the job necessary in the way that would be necessary without cutting corners. So again, it's going to depend on so many contextual factors.
Give an example, if I can interrupt.
Yeah, without disclosure.
At one point when I was president, we were meeting with members in Peterborough, and they talked about fees because people talk to me about fees all the time, and procurement and things like that. And they brought up the case of the fact that, the local, it was like one of the sort of legions or moose lodges or something, had issued an RFP that they needed to do some renovations to their building. And so they had, issued this RFP, and architects in the community had put in their fees, and all the fees were sort of, fairly similar, except one member who had a fee of like $500. It was like ridiculously cheap. It was not even worth doing anything. It was a $50,000 project, and his fee was $500. And people complained and were upset with him. And he said, well, look, I'm a member of the Moose Lodge, so this is how I'm giving back to my community. And, $500 covers what I think is a reasonable cost for doing that. And he justified that incredibly low fee as an act of service to his community group. And, it's wrong. It's terrible to say that you're going to undertake to provide architectural services at a fee, but, it was fully disclosed. It was fair and reasonable to him, and it was fair and reasonable to, whatever the Legion or Moose Lodge, whatever it was. So everybody thought it was, the client and architect both thought it was fair, and both were happy with the result. We may not think it's fair, we may not think it's right, but that doesn't necessarily mean that it's completely unfair in the public interest. And that's, as unfortunate as that is, the OAA cannot set what the fees should be. It cannot say what is a fair or reasonable fee. So
Yeah.
it's an important one that this one comes up a lot.
Yeah, and this is why people hate lawyers, because we always say, oh, it depends. But the reason we say it depends is there's so many contextual factors for any complaint. And I can't say what a complaints committee would have done with that decision. It would have required, weighing of a lot of different evidence. But you're right to point out, Tom, that each complaint is going to come to the committee with its own set of circumstances, and the committee is going to have to grapple. Ultimately, as I pointed out at the beginning of the presentation, the guiding beacon is this in the public interest, and that every argument is going to have to center around. And I'm sure most lawyers will tell you they can argue both sides of the case for why it could or couldn't be in the public interest. But again, that point illustrates very, very well how contextual these decisions are. And then, yeah, there's a couple of others. Obviously, the signing of the report we've gone over. That's a very clear cut. You've either signed or not. But again, there could be some decision on whether, or some debate about whether something's misleading. So I'll never say anything is perfectly 100% black and white. Certainly failing to perform architectural services with reasonable skill and judgment is another, again, generally subjective, but I will say if somebody is found guilty of contravening the building code, it's pretty safe to say that that wouldn't be a reasonable skill and judgment of a member of the OAA. And then we've got this kind of, we call the bucket section. It's 4254, where you have something that is seemingly problematic, but doesn't necessarily fit into any of the other 53 paragraphs above it, which is the conduct or act relevant to the practice of architecture. It's an important antecedent. Having regard to all circumstances, would reasonably, again, subjective, reasonably be regarded by members of the association as disgraceful, dishonorable, or unprofessional. So that could include, we've seen communication that is clearly not appropriate between a member and a client, for example, where it's like denigrating, degrading language, that kind of thing. As much as you may have a difficult client, you want to maintain a professional demeanor at all times. Again, specifically, if you're going to write something down, be very careful about how you phrase your language. As frustrated or as emotional as you might be about the situation, it's never going to be appropriate to insult or use derogatory language. That's kind of the example, but there could be other examples of what would be considered disgraceful, dishonorable, or unprofessional.
And I'd say that as somebody who uses social media an awful lot, and I try to be very conscious of what I say on social media and how I say things. I would never say on social media, Claire is a terrible architect. She's so awful. And, she's just a terrible architect and her drawings are awful. Because that's derogatory and that's, that's disgraceful to say that. What I might say is that, the way that a municipality has, delivered an RFP could be improved, or that, the process itself was unfair or something like that. You have to be conscious of how you say things, because social media is a form of conduct, right? Writing something in an angry tweet, but posting a picture of the dinner you made and how you completely burned the snot out of a steak and it was just awful and it was gross. That's not relevant to the practice of architecture. And even though it's disgraceful to burn a nice dinner, it's not professional misconduct.
Right. Yeah. And I know we have guidelines on social media, and I think they're good guidelines in general in terms of how to conduct yourself in a professional manner. It doesn't mean to say you can't tell the truth, but I think it's more important to ensure that what you're saying. I think a good example, and I remember this when I actually practiced family law for a number of years, and a lot of the clients would come and say, my ex is insert whatever bad word I shouldn't say on this webinar describing them. And I would say, okay, the court is going to be a lot less concerned about the word you just used and more concerned about the evidence that you have to support all those reasons why they're not a very good person. So they're late to pick up their child, or they don't pay on time, or they neglected to provide a healthy lunch. Like, give me examples. And similar to a building, these are the ways that the Again, I'm not an architect, and if I were, I would probably be a very incompetent one. But the roof wasn't done appropriately to account for the snow load or something. These are very neutral, factual, can be updated with evidence. Again, it's much safer to be neutral than to have these judgment words. Again, this could be a whole other webinar. We talk about these issues, but it's safe to say that these are the sections that are going to be relevant when these issues come up. Now we got one. I know we're like 4 minutes away from noon. So again, if people do have questions, feel free to start populating the Q&A. But before we get to the very end, we do have one more hypothetical, and I'll ask Tone if you can read it out, and then we're going to move on to like the best practice.
Absolutely. So
Yeah.
Alex is an OAA member and is approached by a client with a set of drawings prepared by an unlicensed designer. The drawings had been used informally for preliminary discussions, but now the client wants to submit them for a permit application. Alex performs a quick visual review, notices a few minor errors unrelated to the structural design, and discusses them briefly with the client, then affixes their professional seal so the client can move forward. So which of the following actions by Alex would constitute professional misconduct? So please choose one. Sealing drawings that contain minor, non-safety related errors without requiring corrections. Affixing their seal after performing only a brief review rather than a detailed examination of the drawings. Affixing their seal to drawings they did not personally supervise or direct in their preparation. Or reviewing drawings prepared by an unlicensed individual without confirming they comply with applicable building codes.
Okay, again, this is another very specific scenario. So far we haven't really talked about seals, but seals are, again, another area that we do run into on the complaints committee, the misuse of seals, issues around seals. And I've got a bit of a spiel about how important they are to the profession. And certainly, like when I came to the OAA, learning about the seals and the importance of seals, and specifically as it relates to architecture, is very different from other professions. In architecture or in law, we have I'm a notary public, and we'll seal documents, but it means something very different than in the profession. So maybe we can see the results. All right, so then again, we've got most people got this right, but a couple of people were caught up, which isn't surprising. The correct answer is affixing their seal to drawings that they did not personally supervise or direct. And again, there's a very specific relevant sections, 4219. And if you look at the wording of this design, of this section, it says affixing a seal or permitting a seal to be affixed to a design that was not prepared in its entirety under the personal supervision and direction of a member or holder. So the key thing there is that the drawings were not prepared by a member. So it's okay with this if we change the wording of this hypothetical, if the person who'd done the initial drawings had been a member, that would not have met this definition of misconduct. So failing to do that, again, ultimately triggers that more subjective section, which would be failing to perform architectural services. I don't know, Tony, if you had any thoughts about sealing and the importance of sealing.
Yeah, I guess it depends on the scale of your practice. I mean, some larger practices will have, they'll do like a retail, they have a standing offer contract to do, a retail fit up, and, like a coffee shop or a coffee chain or a fast food restaurant. And that company will have their sort of standard drawings or their template drawings for, a drive-through and 30-seat restaurant, and they want just can you just stamp these drawings? And that's something that sometimes happens, and the answer is no, you can't do that because that's professional misconduct. And that means that you need to essentially redo the drawings to suit that project, and that's part of the work. And so if you're asked to provide a fee to do that, you and three other architects are asked to provide a fee to do that work, and somebody says, yeah, I'll just stamp the drawings, you have an obligation to report that. But it's also professional misconduct for you to offer to do that because you know, the drawings aren't personally supervised and directed. I think that the definition and understanding of personal supervision and direction is something that is probably a subject for another discussion. It doesn't mean that you have to sort of sit right next to your intern or your technician and sort of guide their hand on the May line, you know, move the mouse for them. It doesn't mean you have to directly supervise every click of the mouse, but it means you have to supervise and direct the work. And especially in today's environment where we have more people working from home, working remotely, you know, subcontracting work maybe to you know, for a project, you still have to supervise that work, even if it's not at a desk next to yours. It might be a remote workstation, something. There is an obligation to personally supervise and direct that work.
Yeah. We've also just updated our regulatory notice this year on the OAA professional seal. And in the intro, I think it's a good introduction. It says the seal is a solemn confirmation that a qualified licensed member is sufficiently aware of the relevant considerations that went into the design, such that, in the member's opinion, the design is ready for publication and intended to be relied on and used by others for the purposes intended. I also think this is very connected to the fees that are getting charged. So if someone's like, here's a quick few, I don't know what the prices are, but whatever I need this sealed, all you have to do is seal it and then they'll give you this amount of money. Then you're cutting corners. You're not spending this time sufficient for that awareness of the relevant considerations, right? Like that has to be factored in. And I think the role of the professional, of the architect, of the member, is to educate the client of what goes into your professional responsibilities. You're not simply a hired person, hired hack to do a bunch of things, right? You have more responsibilities than a member of the public being part of the profession. And with that, that's how the trust of the public is earned, by the fact that you have that skill and judgment and the training and the ongoing competence, and that you will be responsible if something goes wrong, right? So you're not doing yourself any favors by taking that quick paycheck and doing that quick thing for the risk that something goes wrong. So again, it's always those things that are, you know, those quick, easy things are often, you know, when you do them, oh, they're just doing them a favor. They got to get this. Like that's when you have to take a beat as a professional and decide if it's really worth it. What is the true cost? Ultimately, you could be on the receiving end of a complaint, right?
I think it's worth also recognizing that engineers are not guided by the same thing. So especially at the sort of smaller scale of residential, you might design a house and, you know, give the drawings to a structural engineer who sort of marks up beam sizes and posts and lintels and things like that, which you put on your drawings. And then you might give the final drawings to a structural engineer who stamps the drawings, rather than that structural engineer doing their own set of drawings, you know, for a house, right, which could be fairly straightforward. And so the structural engineer can stamp your drawings and say, you know, for structural only, and then you still have to stamp the drawings. But the reverse is not true. The structural engineer can't do a set of drawings and have this sort of little minor, you know, fire rated door or fire separation, and then you just stamp their drawings. It doesn't work in reverse. You have to do your own. And that's an important thing to recognize, especially if you're doing subcontracted work to engineers. Like we've done, you know, stuff for mechanical engineers, electrical engineers, where they're doing like a multi-million-dollar generator refit on a project, and we're only providing the fire separation and the doors and stuff around it, but we produce our own drawings. We don't stamp and sign their drawings because that's misconduct.
We're at the, you know, we're happy to take questions, but we've also, I'm not seeing anything substantive coming in yet. But I did definitely want to share some best practices I've also got, again, depending on what people want to hear about, some of the factors that go into making the decision. So I would really love to hear from those on the call today what they hear, but maybe we can kind of talk about some really basic. And I will confess on this call, or maybe not confess, but just share that when I was preparing this presentation, I asked ChatGPT if I were an architect or a member of the OAA, what would I do to avoid a formal complaint being lodged against me? And the answer was very helpful. They came up with 9 different best practices that I thought were very things that I had not really thought of. And maybe I'll go through a few of them, and Tone, you can kind of share your insights. But one of the things that, again, I forgot completely about was just covering your basics, like making sure you're staying up to date with the OAA in terms of you're paying your fees, paying your insurance if you've got a practice, and then completing your Con Ed. Because actually that's probably the most common way people have interacted with the complaints committee. We've shifted away from formal complaints, and this cycle will be moving to an administrative suspension. But it is considered misconduct to not complete your Con Ed. So you might think, oh, I'm not, entering all of my hours. That's no big deal. Everybody does it. Everyone's a little, but that's something that will trip up a lot of members. So
It will.
basics, yeah, just keep yourself up to date with the OAA. You don't want to hear from us reminding you 72 times. Everybody here today is getting Con Ed for this, so that's great. But I think that's a really important one. Just the basics is probably going to solve 90% of your issues right then and there.
One thing that I think, on the subject of Con Ed, when I was on council a million years ago, we had this discussion about the importance of continuing education and what should happen on the day of deadline. And the prevailing thought, or one thought at the time, was, if the deadline is you have to have whatever 60 hours, whatever it is, on June 30th, well, July 1st, July 2nd, everybody who's non-compliant is automatically assigned to the complaints committee, because like it's very black and white. The deadline is this, and if you miss the deadline, you miss the deadline. It's like submitting an RFP. You submit, if it's due at 2 o'clock and you submit at 2:01, you miss it. It's black and white.
Yeah.
You have to do your Con Ed, and if you don't, you go to complaints. And the challenge was at the time, and I think this has gotten better now, but the challenge was at the time that the OAA would look at this and say, okay, well, here's 100 people, 150 people who haven't submitted their Con Ed. So they would take time, they would assess that, they would send them a note and say, okay, hey, you missed the your deadline, can you do this? And then some people would, and then some people wouldn't, and then they'd follow up. And so all of that takes a huge amount of effort, because members can't be bothered to submit their hours, and it's your responsibility to do that. It's not the OAA's responsibility to chase you. We're all grown ups, we're all adults. It's your responsibility to do that. It's just as important as paying your pro dem bill, paying your utility bills, doing the payroll for your staff. All of these things are important to being a professional, and so you have to make sure you do that. And as an employer, it's one of the things that I do with my regulated staff is when we do their performance reviews, we look at their OAA transcript and say, like, have you done your hours? Where are you? Are you on track? You need 20 hours before June. So what is your plan to get that? And those are important things that they are each accountable for.
Okay, that's great. I love that you do that. It makes our job easier at the OEA. Because we're approaching end of cycle. Next year will be June 30th will be end of cycle. So the other best practice was having a solid contract. And I'd love to hear your thoughts on this, because it's not a requirement, actually. When you look at the rules or the definition of misconduct, there's no requirement that says you need to have a written contract, but if it just has an expressly verbal contract. So yeah, I'd love to know what your thoughts are on contracts and having run into issues, Tone, like how to avoid problems.
I mean, I go through this from sort of a range of practice. We have sort of a recurring client that we do work for, that we do subdivisions and types of things for, we don't have a separate contract for every single project because that would be administratively burdensome. But we have a standing agreement. We have an expectation of fees, rates, turnaround, time frame. All of that is described, and the general conditions of the OAA document 600 are included with that, so that it's clear what the expectations are. Now, has my client read that? Don't really know. And I don't really care because I've said, in my proposal letter, this is how we're going to do this. And these are the general conditions associated with that. And here's the link to find them. And so is there an individual contract for every block of townhouses? No. But if they, we have other contracts with federal government, with Department of Defense, with Public Works. We have all these other contracts that the contract is more in the structure of a purchase order, or as a standing offer that has a base contract and then has a purchase order for each call up. And so you have to kind of understand the relationship of contracts, purchase orders, and these things, and know that there is a formal agreement that you can tie back to. And I think that's the key part, is that if something goes pear-shaped, if you were standing in front of a judge, how would you describe what your agreement was and expectations? If all you can hold up is, a copy of your Outlook and say, oh, well, on Tuesday, October 2nd, my client and I met for coffee at Starbucks and we talked about our weekend and we agreed that we would also do this, this, and this, and that's it. And all you have is a verbal record of what you said you would do and how much you would charge. The verbal record is only worth what the paper it's printed on. It doesn't stand up very well. What works better is an email, a follow-up, a letter, something that formalizes that discussion. And then being able to go further with that is to say that you have a written contract. Some clients will push back and say, oh my God, your contract is, 100 pages long. I got tired of reading it. What does it mean? And so you need to be able to justify why you have a contract. And that's where the OAA's documents are very helpful, because there's a guideline and it explains document 600. I personally recommend never to use document 800 personally, but document 600, it's very straightforward and there's a good guideline in how you use it. So it's the ideal position to be in, is to use a written contract.
Yeah, and to that end, like flowing from, having a clear contract, is communication, client expectations. I always think about the George Bernard Shaw quote about the problem with communication. The biggest problem with communication is the assumption that it has taken place. So again, this is where lawyers and architects share some pain points. The biggest issue is always boils down to clear communication, like you said, documenting everything. You might not, like the contracts, you're quite right to point out that your client might not read everything. But the fact that and things change. I think what I'm understanding about the profession is that you have an initial project and then there's constant change orders, there's constant things that come up. So making sure that the client is up to date and that you're continually, it's not a one-off. And I think this is where a lot of people get stuck, and myself included, is that it's, as a professional with a certain level of training, you assume, okay, I'm going to explain it this way and it's going to be understood, but really checking in with the client to make sure that they understand. And I think they'll probably, and Tom, please let me know your thoughts on this. You'll have clients who are very sophisticated, who you've worked for a number of years, you have a very good rapport with, you have that kind of flow. You'll maybe need less management, and then you'll have other clients, maybe like a residential client who's never worked with any kind of architect or licensed professional, and we'll need a lot more handholding. Can you share maybe some of your insights in terms of that?
Yeah, sure. So, I was actually just thinking about this. we won a standing offer recently for a small town outside of Ottawa. It's up the valley. This is not a sophisticated client. They issued a standing offer for, 1 million services under the sun. Most of them were engineering related, but they were clear that they wanted architectural stuff. And so they threw architects under category 14, which was general and miscellaneous services. Okay, so I guess that's where we end up. And then, when we wanted a position on the standing offer, they gave us a contract that they had written themselves that they use for engineering services. And they said, the engineer will do this and the engineer will abide by the Engineers Act. And I crossed a bunch of stuff out and I said, so this doesn't apply because I'm not accountable to the Engineers Act. This doesn't apply because I'm not an engineer. And I gave them document 600 and I said, this is a better model for your use, and you should consider using this because when you have contracts that don't apply, like it doesn't work. And in a court of law, if I was to stand there and say, well, I sort of assumed that the Engineers Act would, in my case, apply to the Architects Act. Well, we know that assuming things is a quick way to end up with, I don't know what the rest of the expression is, but assuming is a bad idea. So it needs to be clear. Because if it's not clear, it's not clear what the expectations are. And at the very least, you need to be able to table like, hey, this is what our expectation is. We do design build work for the military, and sometimes the builder will say, well, here's the purchase order we use to engage you. And it's like a purchase order that applies to me, applies to the 2x4s they're going to buy, applies to the concrete they're going to buy. It's not really the right thing. So I'm happy to sign the purchase order as a mechanism on their side so that I can get paid. But I also give them, a standard contract and say, here's the contract. These are the conditions of the contract. And this is an appendix to your purchase order because it's more appropriate to the services of a professional.
Mm-hmm. Yeah, and I think again, where there's an overlap in law and architecture is like I would get a sense when I again was practicing in the area of family law of a client where you could just see maybe where things they were not feeling happy with the process. And a really good practice, again, everyone's going to have their own style, but is to respond or document things in writing, especially if you're having a lot of conversations and then there's an agreement, okay, we're going to change this or we're going to change that. When you document things in writing, it does two things. First, it gives you're putting it down, it gives the client an opportunity to review and make decisions about that information. And then number two, and this is the lawyer part of me that thinks about, like you mentioned, what would this look like if a judge were going to review it or a complaints committee were going to review it? If you're documenting it, then you've got that clear on X, we went to Starbucks, we talked about moving this wall 3 feet over, whatever the change is. And then it's very difficult to argue when things are written down. So I think it's just that, as lawyers, we're very much trained to document. And I don't know to the same extent that architects, I know through your drawings, but through that client communication, what we see in the complaints, from what I see in the complaints process and on the complaints committee side is people often who haven't documented things, who've had a lot of conversations, and you're hearing side A and side B, and the stories, although there's some factual similarities, are very different, right? You don't have the same story. And having a written document of it will serve you well. It might take an extra amount of time, and I appreciate that there's those considerations as well. And navigating a lot of responsibilities. However, it's using that professional judgment that you've all honed over the years to apply, what is the risk of not doing it versus what is the reward of doing it, and constantly maintaining that clear balance. I'm not seeing any more. Okay, here's one question actually from the OAA. How do we handle vexatious and frivolous complaints? which is really a good question. And I think it's important to note that, and especially as a member, you might feel like this is completely unfair, that I didn't do anything wrong. And it is a really important thing to note that because you've received complaints does not mean that you are guilty of professional misconduct. It's unpleasant. Nobody wants to have a complaint. I completely appreciate it. But until the matter has been decided by a discipline committee, there will not be a finding of misconduct. There is, however, a duty on the OAA to investigate and consider every complaint. A lot of other regulators have had to grapple with the issue of a vexatious complainant, and in certain circumstances have made decisions. Since the volume of complaints at the OAA is much smaller, we haven't yet had to come up with that. There's a more specific legal answer in a civil proceeding about vexatious litigants. And again, we don't have that formal structure. But I think it's a really important takeaway from this presentation today that if you are the recipient of a complaint, it does not mean that you're guilty. It's certainly that has to be determined over a course of a series of steps. And the initial referral to the committee itself will be required by virtue of the act. Like, for example, with the Law Society, the act is structured very differently. And there is a vetting process that's done by staff at the Law Society. So if there is what's a panel might view as clearly baseless, will be vetted out at that stage. The OAA doesn't have that mechanism. The complaints committee is the only body that can really consider the investigation and consideration once a complaint is formal and written and submitted through that form.
I think it's also worth recognizing that there's I guess a couple of processes. Is that, you know, something that is assessed by the OAA and considered by the complaints committee is, you know, the amount of information that's available. Is this I can't remember what term is used, Claire, but is it prosecutorial? Is that the right word?
Prosecutorial assessments or viability assessments.
Yeah. So if, you know, if there's something, but, you know, the chances of this going through is small, or, you know, if it's seemingly impossible to chase this because, you know, it's unlikely to be successful. So that's an assessment that's done. And then as well, I think it's after the discipline committee, there is an outside review done by a member of by an LGIC member of council, to assess if the proper process was followed. And that's the discipline review.
That's actually, yeah. So that's sorry to interrupt you. It's before the discipline. It would be available for a complainant, specifically if the matter were dismissed or if it wasn't referred to the discipline committee. A complainant can file with the complaint review counselor, and you're right, it would be a member of the public through an LGIC who's appointed to OAA council, and they can't decide, they can't review the decision and make a different decision than the complaints committee made, but they can see if the process was followed. And what they're looking for is, you know, were there procedural fairness irregularities, and they could recommend them to council that there be changes to the committee. So that's, again, something, if you feel like the process can sometimes, the complainants are not happy that we dismissed, or the committee dismissed a complaint, and so that's their mechanism. There's always the availability of judicial review for any administrative decision, but that again is a bit outside the scope of this presentation.
And
There's a couple
that the, you know, thing that we often see at the complaints committee is, you know, one of the questions that's asked is, what do you want to see done? And the complainant, you know, if it's a client, says, well, I want an apology, and I want my, you know, this done, and I want my money back, or I want, you know, payment of fees. And that's not something that the OAA the complaints committee can do. We can't assign blame. We can't say to the, to the member, okay, well, you have to pay the person back. That's a civil matter, and so we don't address that.
Right.
So if the client says, well, I have this charge of professional misconduct that I'm going to file, and as a result, I want the person sent to discipline and their license revoked, and I want my money back. Those are kind of two separate things. If they want their money back, they have to pursue that through the courts, through a civil case, pro dem, etc. That's a different conversation to have. And it's, we deal with is transgressions of the act.
Yeah, thanks for making that point. And it's something actually in the form, we'll ask the complainant, what do you hope to get out of this case? And we'll guide them to the fact that you're right. The OAA does not have authority to get your project done faster or your fees returned. There are a couple of questions that just came in that are really good. The first one is, are architects charged for the process of investigation? So no, there will not be any charges, any financial consequences going through the complaints process. The only place where financial consequences might unfold are in the discipline, at the discipline stage, where if there's a finding, there could be costs or financial sanctions, but no, the costs of investigations are borne by the association. And the other question is, for members of the public that make complaints with bad faith, are there consequences for them? And I won't say unfortunately or fortunately, the OAA doesn't regulate the public. So I can't speak to consequences like karmically, or there might be other legal claims. You could certainly speak to a lawyer about your rights if you feel that there's been a bad faith claim, or there might be other legal issues like libel or slander. Again, I cannot provide legal advice about that. But within the context of the OAA, we don't have any jurisdiction to take any action against members of the public. The only area that we have any jurisdiction in that regard is for the illegal practice of architecture. So if somebody's practicing in the protected scope and they're not licensed, or if they are using the title architect, or they're holding themselves out as architects or licensed members, then there are mechanisms within the Architects Act. Otherwise, we're limited to only address the conduct of the members.
One thing I would add on that, being a person who is out there often on social media, in fact, somebody attending this committee is already connected with me on LinkedIn, is, I get regular LinkedIn invites of people who want to be my friend on LinkedIn or whatever. And they'll say, oh, I'm an architect. I am an architect, and, I'm working here in Ottawa. And like, it's not that I don't trust people, but if you kind of look at their profile and they went to college, or they're not an architect in Ontario, and they're using the designation, you have an obligation to say something. And sometimes there's been a couple of times that, Claire, don't get mad at me, but sometimes I'll get an intern architect who will say, oh, I am an architect. And I say, well, wait a minute, you just graduated. And they say, well, no, I'm interning. Okay, well, so I'll give them as a little bit of friendly advice and say, before you get your wrists slapped, you should check your ability to use the title and what titles and terms you can use. Or if they're an architect, but not licensed in Canada, but they've just moved here from another jurisdiction, they're trying to get licensed, and they say, well, I'm an architect. I'll give them a little sort of friendly advice and say, you should check what title you're allowed to use, because that's a protected term, and then steer them to the OAA. If it's somebody who's really out there, pushing themselves as a business and saying, well, I'm an architect and I do this, and they're really advertising themselves as a business, I'll sort of screenshot it and then send it to Claire. And I apologize in advance for sending you so many of these. But these things, if it's really egregious, then it's worth sending that in. But you can use your professional judgment that if it's a student, it's an intern, someone who's clearly not really quite understanding what they're doing wrong. But you also can't file a complaint. Like, there's a hairdresser in Hamilton that does hair architecture. There's you know, the architect, the mortgage architecture mortgages or something like that here in Ottawa. There's things that you can't control, and that's really annoying. It bothers me when you read the news and it says, you know, so and so was the architect of the, the architect of this, that, and the other thing, and they don't mean that they were the architect. They mean that they were the, you know, instigator or the designer or the planner, and they're using the wrong term. It annoys me, but
yeah, no, I know. I'm just mindful of the time.
yeah.
We're right at time. I'm going to make one small pitch before Shalika gives the closing announcement for anybody interested in signing up for a statutory committee, specifically the complaints committee. We're always looking for really strong members of the committee. If it's maybe not something this year, maybe in the future, something to consider. The profession is stronger through volunteerism. It's a community of practice. That's how the profession stays strong and vibrant and healthy. Toon is a shining example of that, obviously. And so I just want to make the pitch and also thank everybody for paying attention to this topic today. And I'll stop talking now and hand it over to Shalika.
Great. Thanks so much, Claire. So thank you to Claire and Toon for such a great webinar and discussion today. And thanks also to everyone who has attended and participated, particularly with the polls. So before we conclude the webinar, I just have a few announcements as well. For those seeking continuing education hours, the OAA will record your participation in this webinar on your OAA transcript. So there is no need to individually report. We just kindly ask for your patience at this busy time of year as we process and confirm the accreditation of your hours within the next few weeks. As well, all attendees will soon receive the presentation file by email and a link to the survey to submit your feedback for today's webinar, which we and our presenters highly value. Finally, we have 2 webinars coming up next week. The first is on Wednesday, October 8th at 1 p.m. It's titled Project Genesis. So this webinar is presented by Gregory Enriquez and will include discussion of the new affordable co-op housing complex in Scarborough. And the second webinar takes place the following day on Thursday, October 9th at 11 a.m. with the title Carbon and Net Zero in the Low-Rise Residential Sector. And finally, also be sure to look out for another risk management webinar that we have coming up, which will also be offered at 50% off. So this one is titled Professional Responsibility Under Municipal Renovictions Bylaws. And that takes place on Thursday, October 30th at 11 a.m. So once again, thank you everyone for your attendance. Thank you, Claire and Toon, and have a pleasant remainder of your day. Thank you.
Thank you, Mika. Thanks, Toon. Bye.